many times in the Superior Court, and also in the municipal court context as well, the motion to suppress evidence is the trial. The case is going to be resolved one way or the other based upon the motion to suppress evidence, because if the defendant wins his motion to suppress evidence, the state's case normally is going to go away at that point, because the evidence, they need to prove the underlying offense. The motion to suppress, though, in many instances is the trial, because in the event the defendant is successful in suppressing the evidence, there goes the state's case. Alternatively, if the defendant loses the motion to suppress evidence, the likelihood is that the case is going to plead out, and the defendant will pursue whatever objection he has to it by way of appeal. So this is why it's important when you have an issue that you see that you have a viable motion to suppress evidence, that you go after it. Now, Joe, I wanted to ask you a question about this, and it's really more of a procedural question than anything else in the criminal context. Bill Zarley, whom we both know and love, told me that, especially when the municipal courts began hearing motions to suppress, he said, look, you should be filing a motion to suppress in every single case. It's one piece of paper, and you don't know what's going to happen. And I said, oh, well, suppose there's no merit to it. He said, it doesn't make any difference. It's one piece of paper. Sometimes good things happen. Do you make it a practice to file a motion to suppress in every case, or do you pick and choose your spots?
It is an absolutely regular part of every single appearance that I enter. A motion to suppress goes in every single case.
Now, this is up in the Superior Court, correct?
And the municipal court.
Municipal court as well?
Absolutely.
Okay. And basically your reason for doing that is because either it gives you a free shot at the police officer, or you get additional discovery you wouldn't have gotten normally, or because you may get lucky, or all those things.
Well, enough about my dating life. The reason I do it is that almost invariably there's a search issue. It's very rare that there's not a search issue. That's number one. Number two, it does have, especially in municipal court, although to some effect in Superior Court, it does have a minor intimidating effect on the prosecutor, because now the prosecutor knows that he or she is going to have to maybe write a brief. They just want to get rid of the case without having to do extra work. They're not getting paid to do extra. And also, it takes away that anxiety. You don't want to wind up, almost on the eve of trial when you realize, holy shit, there's a search issue here that I wasn't aware of. And then you tell the judge, listen, I have to have a motion to suppress. Sorry, you waived it, you didn't file it. So for those three reasons, I always file 100% of the time. And in DWIs, you and I know that's one of our biggest and best and most successful defenses. So in every case and every motor vehicle case involving a DWI.
Let's go through the rule really quickly, just to kind of underscore the things we've been talking about. Just in terms of jurisdiction, the municipal court shall entertain motion to suppress evidence seized without a warrant in matters within the trial jurisdiction on notice to the prosecuting attorney, and if the county prosecutor is not the prosecuting attorney, also to the county prosecutor. And we talked about this, and Joe, you really ought to mention that to the individual who you know is involved in that Supreme Court committee. I can't remember his name. It's something with an M. All right. A motion to suppress evidence seized pursuant to a warrant, and motions to suppress evidence seized without a warrant, but beyond the trial jurisdiction of the municipal court, shall be made and heard in the Superior Courts. Remember, we talked about that. If you have a warrant, that's where it's going to go. Now, the question that comes up, I anticipate there's going to be telephonic search warrants issued out of municipal court for the police out on the street when they're doing motor vehicle searches. They may have a lot of evidence they're going to uncover, which will be municipal court type evidence. And I suspect that if this occurs and there's an influx of these types of cases, that they'll allow telephonic search warrant cases to be heard in the municipal court. The only problem you're going to run into, you're going to have a municipal court judge who's going to be ruling on the bona fides of the granting of a search warrant done by a Superior Court judge. I see that as kind of like a turf war. So we'll just have to see as time goes on how this is all going to play itself out. All right? Here's the procedure under B. Briefs in support and of opposition to the motion to suppress evidence shall be filed only in the discretion of the judge. We talked about the reasons for that. Who shall determine the briefing schedule? So the judge will decide who goes first, if briefs are permitted. All motions to suppress shall be heard before the start of the trial. So that's the only limitation you have in terms of time, as I indicated. They all have to be done pre-trial. You can't be bringing up a motion to suppress evidence, in the middle of the trial, because you just can't. Actually, you will have waived it by that point. All right. Here's the stay. An order granting the motion to suppress evidence shall be entered immediately upon the decision of the motion. Within 10 days after its entry, the court administrator shall provide a copy of the order to all parties, and if the county prosecutor is not the prosecuting attorney, also to the county prosecutor. So the prosecutor will get a copy of the order suppressing the evidence. All further proceedings in municipal court shall be stayed pending a timely appeal by the state under Rule 3:24. That's specifically Rule 324C. Again, it doesn't say here, but in the rule there, it's a Superior Court rule. The limitation there is 20 days. Property that's subject to the suppression order shall, if not otherwise, subject to lawful detention. For example, if it's, by that they mean, if it's contraband per se, like marijuana, okay, that's contraband per se, that's not going to be returned to you, okay? But anything else, your penknife or your baseball cards or whatever it is, your 1975 Mets poster, that you can get back, all right? Shall be returned to the person entitled to it only after exhaustion by the state of its right to appeal. Now here's the order denying suppression. An order denying suppression may be reviewed on appeal from an ensuing judgment of conviction pursuant to 323, which is the normal appeal rule, all right? Whether the judgment was entered on a guilty plea or on a finding of guilty following trial. So this is what preserves the motion, the issue for you without you having to file a conditional plea, assuming though that we're talking about physical evidence, and that physical evidence part comes through the case law, all right? And here's waiver, and this is very important you understand this. This is where this is why Joe files these motions in the first place. Unless otherwise ordered by the court for good cause, the defendant's failure to make a pretrial motion to the municipal court pursuant to this rule shall constitute a waiver of any objection during trial to the admission of evidence on the ground that the evidence was unlawfully seized. So Joe gets around this, as he indicated, just from a practice standpoint, by filing these motions in every case. Everybody got that? That's one less thing you have to worry about.
Listen, I got to tell you, I had a case in Superior Court where, before a judge who was known as being the ultimate state's judge, Judge Kugelmeister, he was to the right of Attila the Hun, and our guys had like 5 pounds of cocaine or something in the trunk, and the public defender, it was a state police search, and the public defender didn't file a motion to suppress, and he pled his client guilty, and he got a pretty decent deal. He got like 3 years in state prison as opposed to, it could have been 5 to 10. And I filed a motion to suppress, and for the first time in the judge's 20-year history, he granted a motion to suppress. Well, now I got the public defender hanging out there. He didn't file a motion. He pled his guy guilty, and his guy is supposedly going down to state prison. Now, fortunately, the prosecutor and I approached the judge and said, look, you got to let him take back that deal. You can't make him look bad. Let him file a motion to suppress, and then you just simply say because it's the same faction. And he did, to his everlasting credit. But it was not a happy day for that public defender when he found out that the judge granted my motion to suppress.
Let's talk about the rule up in the Superior Court, because the procedure is different in the Superior Court, markedly so than in municipal court. 357 is the rule that controls everything up in the Superior Court. And Joe, I have to ask you a real quick question. If you don't know the answer, that's fine. But my understanding was in the old days, you used to have to do your motion to suppress evidence within 30 days of the return of the indictment. And I don't see that in the court rule anymore. How do they work it up at the Superior Court now?
All right. The answer to your question is this. There are no specific time limits. And in point of fact, in Superior Court, because no one wants to have a PCR and have this come back down after a conviction and spend 5 more years litigating this, there are just no rules. Whenever you file it, you file it. And if you file it at the last minute, they'll yell at you, but let you file it. They'll get really angry at you, but they'll hear it. But what we generally do now is we have a status conference.
Right.
And judges right away say, what are the motions? Now, you better know, if you have all the discovery, you should know pretty well, certainly 90% of your motions. And I always say, usually a motion to suppress the statement, sometimes change of venue, whatever it may be. And then I always put, we reserve the right to file any motions with respect to the indictment, the grand jury indictment, because we haven't received the grand jury minutes yet. And the judge says, of course, and he puts that in it. So generally speaking, judges will press you, always press you at the first status conference, which is within 30 days, to what motions do you have. Now, sometimes those motions don't arise until 2 or 3, status sessions down with respect to maybe cooperating state's witnesses.
Is that because you haven't got all the discovery sometimes?
That's correct. And as the case evolves, and as you get, sometimes they can do cartons of discovery, and it takes you months to go through it all. I mean, literally, you're supposed to technically go through it the very first night, but it takes months. And new issues arise, or subtle things will occur to you down the road. And the truth is, in the Superior Court, judges just say, fine, whatever let's just brief it and let's move on with it.
Okay.
They do not press you for time.